again. Perfect. I will share my screen. All right. So now you should be able to see my screen fully. And so after the introductory speech of Professor Commandé, who has just well highlighted the ambiguity entailed in the European data protection framework, which on the one hand aims at protecting fundamental rights of the data subject potentially involved in research activities, and on the other hand provides a regulatory basis for enabling research activities and thus also for enabling the sharing of personal data. So based on these premises, my presentation directly aims at shedding greater light on the research exemption and on the role of data protection principles in practices related to data sharing for research purposes. Now, first of all, why do we talk about a data protection research exception? What does it exactly mean? Professor Commandé has spotted a few regulatory points in the general data protection which derogate, as we have seen, from the ordinary data protection framework in the form of derogation to data protection basic principles, as the basic principles of storage limitation or purpose limitation. We have seen the possibility of for the data controller to perform a compatibility test so as to legitimize further processing of data. We have seen the possibility, finally, of the derogation laid down by the General Data Protection Regulation of specific data subjects' rights in terms, for example, of the data subject's right to erasure or data subject right to receive a specific type and a specific kind of information regarding the ongoing processing activities. And I think it is exactly in this derogatory regime related both to basic data protection principles and data protection rights that we can identify first key features of the data protection framework regarding to research. And it is exactly in light of these admitted derogations that we can talk about an outright data protection research exemption. But actually, things are much more complex than this, and the data protection research exemption is still object of ongoing interpretation. The European Parliament last July has issued more guidance about the framework, the data protection framework regarding research activities. Also, the European Data Protection Board has given its insights on the interpretation of some critical points that the regulation of research activities from the data protection side raises, and we will see them in a few minutes. Now, in order to have a deeper assessment of the data protection framework regarding research, actually, we have to go into the very special regulation of sensitive data. Under the General Data Protection Regulation, special categories of data are specifically taken into account. Special categories of data are sensitive personal data, as for example, health data or personal data about races or ethnical origins. And under the General Data Protection Regulation, these special categories of data are generally prohibited. The processing of this kind of data is generally prohibited, except for some conditions which are laid down under paragraph 2 of Article 9, which lays down some lawful basis for the processing of these special categories of data. And among these lawful bases, bases, it is extremely interesting to find an explicit reference for research. This means that the General Data Protection Regulation enables the processing of special categories of data, for example, health data, which, as we all know, especially in these times, are especially valuable for research purposes. Uh, of course, research is a first lawful basis for the processing of these special categories of data, but the regulatory regime is quite complex. Indeed, as Article 9, Paragraph 2, letter J of the GDPR says, that the processing of this kind of data is allowed for public interest, scientific or historical research purposes or statistical purposes. So you immediately see that the definition is very, very broad. But the definition, it also demands data controllers that are researchers handling those data set, including special categories of data as health data, to first look at union or member state law in order to identify whether the processing activities that they're carrying out fall under the notion of research or statistical processing activities that has to have a clear legal basis under union or member state law. So the first thing that a researcher has to do is actually to verify whether the occurring processing activity find a legal basis, can be included in the notion of research as laid down by union or member state law. Usually these definitions are quite broad, so usually actually the answer to the question whether the processing activities could fall under research processing activity is affirmative. But that data controller have to do under the considered provision a further step. Indeed, they have to assure that the processing of these special categories of data is proportionate to the aim pursued, that is, the research aim, and they have to respect, data controllers have to assure that their processing activities respect, as the General Data Protection Regulation explicitly has to respect the essence of the right to data protection. Now, these very general, as it may appear, expression of essence of the right to data protection actually very concretely requires data controller who may take advantage of the mentioned derogation to actually do not go beyond or below a certain level of protection. And in order to do this, the General Data Protection Regulation under Article 9, Paragraph 2, letter J, explicitly requires data controller, as Professor Comandé was already mentioning, to implement additional technical and organizational safeguards. Now, these additional technical and organizational safeguards have to be based again in union or member state law. So member state law can define and can provide clearer guidance about what exactly these additional technical and organizational safeguards have to be in respect to the specific research processing activities. Nonetheless, already from a general reading of the data protection framework, some specific safeguards can be immediately identified. For example, Article 89, Paragraph 1 of the GDPR expressly mentions pseudonymization. So that's required controller to implement pseudonymization techniques over employed data sets. Of course, data protection impact assessment in light of the risk-based approach of the data protection framework is absolutely useful in order to assure the respect of the essence of the core data protection protection right. And of course, also the following of sectoral codes of conduct can be useful for the purpose of implementing an effective apparatus of technical and organizational safeguards. Of course, when it comes, for example, to research over health data sets, of course, also ethical guidelines and the respect of ethical values and principle is absolutely key. Now, what is important to say in respect to this requirement of implementing additional technical and organizational safeguard is exactly that the burden of protection shifts to the data controllers. So it is absolutely up to data controller to evaluate on a case-by-case basis which are the technical and organizational safeguards which in the particular processing situations are needed in order to protect the data protection rights of the data subjects involved. And this individual based to case by case assessment actually could require data controller to implement stricter technical and organizational safeguards when the possible derogations to data protection principle and rights are fully exploited, and when, for example, the data protection impact assessment reveals the existence of a great risk to data subjects' rights and freedoms. Talking in more concrete terms, of course, when it comes to for-profit research, then of course the risks to data subjects' rights and freedom will be greater, and so the technical and organizational safeguards which controllers are required under data protection law to implement have to be higher. Conversely, when the data protection principle and rights are fully respected in the ongoing processing operation, and the risks to data subject rights and freedoms are minimized and are not identified as severe. For example, this is the case of public interest research, where the risk, of course, to data subjects' rights and freedom shall be lighter. Then also the technical and organizational safeguards can be lighter under the data protection framework. Now, very last short remarks about some critical points of this special data protection regime. Now, from a combined reading of a recital, which is 162 of the General Data Protection Regulation and Article 89, we can derive the so-called principle of segregation. This means that research activities cannot result into processing for commercial purposes, that is, for purposes which are non-research related. Now, this general principle, of course, of segregation poses some concrete practical problems, especially in case of further processing. We have mentioned before the existence of a compatibility rule, which actually enables further processing activities based on the assessment of the compatibility of the purpose of the further processing with the original processing. But actually, when can we say that in research activities, which are likely to encompass a great variety of different research processing activity, when is this compatibility respected? Of course, first answer to this question can be given again in light of the consideration of the differences between public interest related research and for-profit oriented research. So it is important for data controllers to explicitly take into account the difference in type and in objectives of the research that they are pursuing. For example, a research which pursues public health objectives is of course different from a research that targets the development of a specific device that will be later marketed. And so this is the first distinction that is worth to highlight. Of course, further problems, of course, arise when there is the case of the change of the lawful basis. For example, and the question has been raised also in case law, whether the withdrawal of initial consent by data subjects involved, which had released their data for research, their personal data for research purposes, whether this withdrawal of consent legitimized further research for further processing for research purposes exactly based on an autonomous lawful basis of research or not. Here, the answer are still unclear. For example, the European Data Protection Board has admitted that further research is still possible, given that technical organizational safeguards are implemented. When there is, despite the withdrawal of consent by data subject. Conversely, the European Commission has actually given an opposite interpretation and has taken consent as the golden benchmark of data protection law. And when consent has been withdrawn, then no further processing is possible, although this processing pursues research objectives. Now, on the basis of this very complex data protection framework regarding research, I want to do a very last remark that can serve also for the further speeches, which will deal more concretely with IP issues, that the data protection principles and rules have to be taken by data controller, by researcher, as the very benchmark for every research activities, and especially for research activities involving the sharing of personal data. For example, the principle of fairness, of accountability, of non-discrimination have to guide the sharing of personal data, be it, for example, in the most remote hypothesis of competition-based sharing, but also in the hypothesis of, for example, licensing contracts, all which involve and include also personal data. These licensing contracts should absolutely move from data protection principles, which sort of trace the basic framework for a fair, accountable, and non-discriminatory data sharing environment for research. Thank you. I will end my
Thank you, Julia. Meanwhile, the others are preparing. Let's try to constrain, if possible, in no more than 10 minutes the presentations, so we can have also some time before finish for questions. You can begin also to write questions if you have on the chat.
Can you see my PowerPoint?
Yes, go on.
Perfect. So good afternoon, everyone. Happy to be here with you. I will try, as requested, to be as short as possible. My task in the next 10 minutes is to give you a very brief overview of IP-relevant aspects of research infrastructure and online practices. I will keep my presentation very basic, taking as granted that you're no expert of IP, but you're expert of research infrastructure. So I just want to give you ideas of what are the problems we may face or things we need to take care of when we deal with research infrastructures IP-wise, both as owners and as potential users of research infrastructure. Now, in order to understand how to frame the problem, I wanted to start with the definition of research infrastructure that is given by the ERIC regulation, so European Research Infrastructure principles that were framed in the regulation of the Council 723/2009, containing also intellectual property norms and policies for European research infrastructure. They refer to collections, archives, infrastructure for scientific information, and ICT technology-based infrastructure such as grid computing, software, and communication. So on this basis, if we need to think about which intellectual property rights are involved when we deal with research infrastructure, we generally need to phase from the most to the least involved. Database protection, which is covered by copyright and sui generis right. I will tell you in a couple of minutes what that means. Copyright, trade secret, and patent. Now, every time we talk about IP rights, we talk about rights that are exclusive and they are basically proprietary. So differently than data protection norms, these rights tend to be more perceived by judges and more perceived like legal operators as proprietary rights. They have also another characteristic that makes our dealing with them kind of problematic, is that they are territorial. What do I mean with that? That you are protected just in the country where the right is granted to you. This is particularly more visible when you deal with registered rights, like patents or trademarks can be, a little bit less with copyright and database rights, but still, you should imagine these rights exactly like a house, a building. They are territorial. You apply to them the law of the place where the right was conferred, and that right is valid only within that border, those borders. This creates, of course, several problems when we operate online because you can infringe rights in a way that you don't even realize, or you may believe that the right exists simply because that particular research infrastructure is available online, but at the end of the day, that's not actually protected in your own country. So the framework is, and the patchwork is even more complicated than what can look at first sight. Now, the scenarios you can face when we talk about IP and research infrastructure is twofold. And you can be the one who's building the platform. You can be the one who's using a platform built by others. When you're building the platform, the questions you need to ask yourself before is who owns the platform, according to which rules? What is proprietary? What cannot be owned? Because there are elements that can be owned, elements that are free by definition. And then the third and last question is which intellectual properties are to be applied to which elements of those of the research infrastructure, which rights are conferred, and how long do they last? On the other hand, if you're the one using the research platform, a research infrastructure of someone else, first question first. Do I need a license to use it or not? That depends on the regime. Or am I authorized otherwise, without a contract? Am I authorized because that's following a different regime, an open regime? Or am I authorized by law through what is called an exception to those exclusive rights? Now, if you look at that's a chart which I taken from a mission document, that actually gives you a slide of the type of rights that can be applied on different realms of the research infrastructure. On the left column, you have all the potential IP rights. On the right, the very first row, you have all the different items present in the research infrastructure. You can see, depending on the type of object you're talking about, you may have overlaps of intellectual property rights. If we are in a proprietary realm, that's more or less the grid you face. The website may be protected by copyright or design rights, depending on the characteristic of the website itself. The graphic user interface is not protected by copyright, so that's free to use and free to copy eventually. The data set which you are using can be protected by database rights or trade secrets, if it's protected at all. The software can be protected by copyright or patent. Now, very briefly, can someone tell me, since I don't even have a watch in front of me, how many minutes I still have? 4, 5? How am I standing compared to the 10 minutes?
Go.
Am I standing? Okay. So,
8 minutes.
Okay, thanks. So, copyright. Copyright is a bundle of economic rights and moral rights. You saw what it could stand. That's a very pervasive right that covers copying, covers distributing, covers posting it online, like communication to the public, displaying, adapting, translating, whatever. Don't touch it. It burns. Moral rights are paternity and integrity. bundle of economic rights, they can be alienated, they can be sold, and they can be licensed. Moral rights, you can't do anything with them. They are just yours. They are personality rights. They cannot be sold. They cannot be licensed. It lasts a lot. 70 years post-mortem autoris, so 70 years after the death of the authors. It depends on the subject matter. Sometimes it might be shorter. You get copyright from the very act of creation of an original work, so you don't need to register anything. There are countries giving you a broad list of potential protectable works, other giving you closed list of protectable works, and there are specific exclusions, so items which are not protected by copyright. We are talking about facts, ideas, flags, insignia, governmental or public acts. Depending on the country where you are, there are objects, subject matters, which are excluded from copyright, even if they look like copyrightable works. Every law also provides specific rules to define who can be defined as an author or co-author. And as well as any other IP right, those exclusive rights can be derogated by exceptions. Database rights, that's the one that interests you the most when you handle data. A database can be protected both in its structure, so the originality in the way our materials is structured and arranged, that's copyright. And then you follow all the rules and all the rights which we saw under copyright in the previous slide. Or in Europe, you have something called sui generis right. What's that? That is granted to you every time you have or you put a qualitative or quantitative investment in collecting, verifying, organizing the materials. Every time you make this investment, for the very fact that you're investing money in organizing the content, you get an exclusive right of extraction and reutilization of the whole or substantial part of the database. What does that mean? That people cannot just come in and extract or come in and reuse the material which is in your data set. They need to ask an authorization to do so. And this authorization needs to be asked for 15 years from the moment when the investment was made. And watch out, because it's not a right that after 15 years expired, because every time you put a new investment, qualitative or quantitative, in collecting, verifying, organizing the materials, then the counting restarts. Then you get again a sui generis right. Exactly as it happens for other type of protection of data sets, the right over the whole, over the database, doesn't influence the right that people may have on single elements of the material. And it doesn't have an impact on public domain either. So you should split in your mind the right you have on the database as a whole and the right which you have on single items, on single materials. Also under database rights, you have independent exceptions, and this is something with Julia Priora we'll have a look at later on, because it's a very interesting element for those who are doing particularly artificial intelligence and machine learning activity. Trade secret, very briefly, it's an IP right, kind of strange one, because it protects just elements and information, pieces of information which have a commercial value. They are known only to a limited number of people, and you put under specific measures of protection. This means that as long as you protect them, they are protected. If you don't password protect them or keep them within the walls of your firm or research infrastructure, then the protection simply vanifies. The protection is potentially perpetual, but you cannot force people not to have access to the material otherwise. So it's a very thin protection in this sense. Patents, the very last, particularly on software in case, is on inventions, so technical solutions to technical problems in all fields of technology. You also have specific exceptions here, so there are particular inventions that cannot be subject to patentability. You can patent inventions which meet specific requirements, so novelty, inventive step, industrial application, and the like. This is a right of producing, commercializing, and importing the good, service, or process which you have patented. It lasts 20 years from filing of application. Patent is something which you obtain by applying to a patent office. And here you have. Now, one size doesn't fit all. What do I mean? That the IP status of research infrastructure depends on the rules underlying its creation. So before just starting getting a headache saying, oh my God, how many proprietary rights there are on the research infrastructure, you should breathe and understand Let's see under which regime this research infrastructure was built. Does it belong to the European Open Science Cloud? There is a typo, there is EOSC, not ESOP. Is it an ERIC research infrastructure? These are data subject to any open access legislation like the one Professor Commandé gave you a hint before, like the PSI directive. Did I develop them under my data management plan under the Open Data Pilot or something alike? Or that's something that was developed under a privately research fund, which is subject to specific contractual arrangement. So don't think about the fact that the answer is 1 to 0. It's a bit more complicated. It very much depends on the regime the research infrastructure is subject to. So you may also have non-proprietary regimes that are on the legislative basis, like PSI or open data, or they can be under soft law regimes, like depending on your own personal agreement or adherence to specific groups, like EOSC is. So instead of having copyright or database rights, you may have Creative Commons licenses that give free access, so copyleft, or you may opt for open data structures. Under patents, you can go for a declaration of non-enforcement or free licenses, or what you are producing might even be released by you without patenting, and that goes in free, in public domain, in prior art. So as much as you have a proprietary solutions, you also have non-proprietary free use solutions. And with this, I actually conclude, if you are the user, checklist, first of all, check the regime the research infrastructure is subject to. Is it legislative? So is it under some legislative umbrella, like PSI, or is contractual? If it's contractual, then have a look at the conditions of the contract. And beware, because when you deal with research infrastructure, there might be favorable licensing schemes which you can use and you can enjoy, like fair terms, like FRAND terms, which are exactly the same for patents, particularly standard essential patents. You may have collective licensing schemes or open access agreement you can use. Always talk with your data protection officer or with your lawyers, because they will be able to guide you in this net. So don't immediately jump to take your pocket and pay, or don't immediately jump to infringe. Hold on, buckle up, and ask your lawyer, because there are several different possibilities. Last but not least, and with this, I immediately pass the floor to Julia, who will discuss in details matters that are regarding this realm. You might be the addressee of an exception or limitation. And research is one of the most common examples of justification for which the legislator accepts your users from the exclusive rights of a producer or a right holder. So you can free use without asking for authorization, completely for free. And this is time to focus on exception. The ground is now to Julia to go ahead. Many thanks for your attention.
Thank you very much. I promptly share my screen, and I fully promise I will be so concise. You can bear with me just maybe 7 minutes. That's my goal now. I hope you can see my slide. If anyone nods, okay, great. Yes, perfect. I think it's the right time just to check together what is the role of copyright exceptions. And we have already heard the word derogation, the word exception being particularly crucial for you as an audience, for us as researchers, and for the research environment broadly intended. Well, let me just highlight it. We are having this wonderful webinar and this panel in times where all the legal disciplines and all the discourse we are currently working on is actually on a very hot season. So I'm sure you kind of grasped in the public domain or in the academic debate how much is going on in terms of reforms and indeed public opinion and debate. One of these, let me share probably, one of the most debated point currently pertaining to the 2019 last year is actually the new directive on copyright in the digital single market. I'm pretty sure most of you have heard of that or just grabbed something from the news. Well, the overarching aim and the intention of the European legislator right now at this very moment is to bring copyright forward, level it up, and make it fitter for purpose in the digital world. So we are talking a lot in the copyright as well as in the data protection discourse of looking at the digital single market and looking at cross-border uses of data, of research information, of content, and see how we can make it more fit. So I will be focusing, as promised, only exclusively on one part of this directive, which is exactly related to the exceptions and limitation. Why I do so? Well, if we see that the research environment is filled of a variety of practices and techniques, well, one of these practices, which is really crucial right now, if we look at the copyright legislation, is the text and data mining practice. So I just posted here for your, I'm sure every one of us has some sort of sense of what this means. Basically, the word text and data mining refers to electronic and automated processes which help us retrieving and processing and analyzes big quantity of text and data resources in order to identify patterns, features, interrelations, schemes, and frames, both in their semantic structure and substantial content. So that's something that goes way beyond what we used to call the reading of material and the copying of material. This is something more automated and definitely more profitable in terms of quantity and quality of the outcome. These, as probably by now you have already fully clear in your mind, this comes with a bunch of legal restrictions, not only from the classic idea of copyright being reproduction, distribution, communication, distribution, any act which has to do with this sort of material which is protected by copyright, then face a restriction in copyright itself as a regimes. Professor Sganga has already highlighted the importance of database rights and sui generis database rights, which come in addition to this legal framework. But also we saw in the opening, in the first two presentation, that also extra copyright restrictions are there, data protection being one of the most important. Other potential intellectual property rights, trade secrets, for example, maybe not so common in our lives, but why not? We are dealing with mass, with big bulk amount of data and content. There may be something with a trade secret attached to it. But the legislation comes not only with punching us with some sort of problems, but also leaving us good freedom and good leeway with precious opportunities. First one, as you just heard mentioned, the research exception. Well, until 2019, very last year, when the new directive was adopted, this was pretty much the only exception we could rely on when it comes to text and data mining activities. Why? Well, no other exceptions, and I'm talking here in the European contents of harmonization, was actually envisaged for research practices, for example, the text and data mining. The big problem, we still have this exception. This exception is there in the InfoSoc directive, allowed to be plucked from that directive and applied by the national legislator in the member states. The problem is that this is not a mandatory exception. It's optional for national parliaments to take and apply within certain conditions. So quite inevitably, we have an implementation across Europe which is not uniform. What the new directive has given us is actually a quite big news. We have now two new exceptions which look at the text and data mining, which are both mandatory. So all by the 7th of June 2021, very soon, all member states will have to implement both these exceptions in the form they are. Well, I just briefly describe them here for you on the slide. Article 3 of the new directive introducing an exception for the extraction and reproduction of works, of protected works and subject matter by research organizations and by cultural heritage institutions for the purpose of scientific research. As you see, the scope is limited within, looking at who is the user, as Professor Ganga was also highlighting. Article 4, on the other hand, has a slightly broader scope. As you see in parentheses, there is no restriction by who is using, so potentially is anyone. Yet the extraction and reproduction of these parts of content or text or data is to be within the scope of the purpose of text and data mining as a practice, and could be actually overridden by contract, because if the copyright holder expressly reserved the right to access and use these bits of information for text and data mining purposes, then the exception will not find application. This leads me to highlight one very last point of the panel of today, which is the importance of licensing and of contractual arrangements. We all saw the emerging and the booming of private ordering, what we call private ordering in legal jargon. What also Professor Ganga mentioned being non-proprietary models. So we see really a flourishing of not only awareness, but also use of licensing models, for example, the Creative Commons licensing, but also the flourishing of repositories which fully embrace the open access idea. And we see also individuals, researchers, people working in the field, which are waiving sometimes their rights and their copyrights to promote a wider access and use of their own content. This hasn't passed unnoticed before the eyes of the EU legislator and in turn of national legislators in Europe. We have, first of all, a big decision, which is the EU-funded research will always lead to outcomes which are open and broad, accessible in a way that is as broad as possible. We have some initiatives, I mentioned here some, and probably the most famous one, which are also trying to build up a regulatory vision of openness within our research arena. We have legislative reforms at national levels. We have experiences, for example, the Spanish one, the German one, the currently still under discussion one, Italian one, which try to pursue this wider access in research and scientific content by way of reforming their copyright laws. Now, I just listed here what are the main features of these experiences that we are analyzing. First of all, not to underestimate, through these reforms, through embracing some sort of exception, derogation, and dimension of the open access inside our copyright legislation, we have a first legal definition of what an open research infrastructure or an open access repository is. This is a crucial point, not only for lawyers, but also for those benefiting from the research environment. We have sometimes, for example, in the draft law, in the proposal bill that is under discussion in Italy, sometimes a difference between natural sciences on the one hand and social sciences and humanities on the other. This is something that probably in the discussion we can also, if you're interested, discuss further. We have definitely a focus on publicly funded research. So we really want to look there to start building the culture of open research, because there is where we can argue there is no need for an incentive. We have public money funding research. That research outcome must be open and accessible to everyone. These reforms almost all hint at the direction of an unwaivable right to a second publication. So this is obviously a big step ahead. This is looking at researchers, looking at our copyright laws and saying, well, we want researchers to be able after some time, so in a delayed form, and now I'm telling you how long this embargo is, we need them to be in full exercise of the right to publish it for non-profit purposes on an open access repository. This delay varies the first legal experiences we find, and I just mentioned to you, usually tend to stick within the range of 6 to 12 months. So these are the months where the publishers, for example, or whoever the researcher has licensed their in an exclusive way his or her rights, can actually enjoy this exclusivity, but then the research outcome will be open and published and accessible by everyone. Very important, since I started by highlighting how crucial the role of licensing, private ordering, contracts is in our field, not less than any other field of private law. Well, these rights coming with the possibility and the duty in some of the examples, for example, by EU-funded research, of making our own research work accessible comes without the possibility of having it overridden by contract, and therefore in a quite effective and straightforward way. Are we heading really, in light of what we have talked and presented to you so far, within the data protection regime, within the copyright one, are we heading towards an open and sound European research area? My personal view, and probably shared by the other speakers we will see during the discussion, is that it's too soon to tell. Obviously, coming from the copyright scenario, we are expecting big data, big observations and conclusions to be drawn by the implementation of this directive in our member states. Definitely what we see is that there is really a focus on making our own copyright exception and limitation effective in Europe. So this is becoming an integral and essential part for a well-functioning of our research area and practices. On the other hand, a lot of discretion, Professor Skanga was highlighting, IP rights are territorial. There is still a heavy discretion by national legislature, and there are best practices that are really important. The legislature look at them and say, let's find out best practices and follow them, but these are in theory. These are still, let's say, it's preliminary to identify which these best practices in most of the cases really are. So probably the way ahead is still long, probably not so easy, but definitely there are good signs of the fact that we are moving ahead. And I think this was really my last slide, so I stopped sharing the screen, and I guess I give the floor back to Julia Schneider.
Thank you, Julia, for this very insightful presentation. And now the floor is open for questions. So if there are any doubts, any also considerations regarding to what has been said today, we are available for answers.
As usual, you can also send questions and issues also by email. If you can set the question in the public, that might be more useful also for the other people. And we will also take into account your reaction by emails for setting the next awareness panels that now are envisaged, if I am not wrong, in early spring 2021.
Yes, exactly.
Since we're almost out of time, so be quick in reacting for questions or reserve them for the email, and we will get back possibly in another happening.
So if there are no questions, we can consider this webinar closed, and we are looking forward for questions through emails. So have a nice evening, everybody, and take care.
Thank you very much. Thank you, Julia,
Thank you.
also
Bye.
for sharing.
Thank you.
Bye-bye.
Bye-bye.